Mr. Millington.
My Lord, before Mr. Stevens reverts to the issue of the appeal, can I briefly address the questions raised by my Lord Stevens before the short adjournment? We've spoken to Mr. Sipasad, and he's indicated that the prevailing practice in Trinidad and Tobago is that costs are awarded in favour of successful constitutional litigants. And that indeed is why Mr. Sipasad challenged the Court of Appeal's reasoning in this case. And he has indicated that he has never seen any case in which that practice was not followed. He's not, of course, making any claim about universality. He's not in a position to do that. And that's his indication to my Lord's first question. And indeed, for completeness, he pointed out that the Arni principle is applied in practice, and we've seen examples of that in these proceedings, Justice Rajkumar's decisions below. On my Lord's second question, the response is that there is in Trinidad and Tobago no general practice of prisoners resorting to constitutional proceedings to secure commutation under Pratt. That being the case, there is no general practice as to any position adopted by the Attorney General in such cases. I think that was my Lord's question. So, my Lord, those were the responses.
Thank you, Mr. Millington. Mr. Stevens.
My Lord, just on those points that have just been made, my understanding, based on instructions, is that prisoners do resort to these applications, and this is just one example of such applications. It is also right that costs orders are often made in favour of successful parties on such applications, but it is also the case that the state does not ask for its costs in the High Court on such an application if it is successful. I can't assist further than that, but that's my clear understanding of the position based on Mr. Almeida's instructions and experience. My Lords, the respondent submitted that the appellant has not shown how the Court of Appeal has erred. Well, you have my submissions on that, and I won't repeat them, but in our submissions yesterday in our written case, and in our written case the references are paragraphs 4, 5, 13, 16, 28, 32 to 33, 36, 40 and 43, we have sought to address various respects in which we say the Court of Appeal erred. But, in short, as we submitted yesterday, the fundamental error, we say, in the Court of Appeal's approach was to approach the matter on the basis that it called for open-ended resentencing for the original offence rather than constitutional relief. Now, the respondent further suggested that the distinction that we draw between sentencing and constitutional relief is a false dichotomy, because the exercise in sentencing is the constitutional relief, he says. Well, there's a risk with respect of getting stuck in semantics here. The important questions are, first, what is the nature of the power the court is exercising? And second, what is appropriate redress? And that's, we submit, how the matter should be approached. It appeared to be suggested yesterday by the respondent. I say appeared because my note does not record that Mr. Sipasad referred to paragraph 11 of Lendor, but rather that he referred to paragraphs 12 and 13. But I think he may have meant to refer to paragraph 11. It appeared, therefore, to be suggested yesterday that what was said at paragraph 11 at Lendor at 766 does not apply to the present case. Now, I mean, that was the passage in which Lord Hughes put matters succinctly as follows. I summarise: the original sentence of death was lawful, indeed mandatory. All that's become unlawful is carrying it out after unreasonable delay, and that is what the court is remedying. Now, he submitted that that doesn't apply to the present case, and I readily accept that Lendor concerned executive clemency, but we respectfully submit that what was said by Lord Hughes in that paragraph is equally applicable to an application for constitutional relief under Section 14. Next, as to the suggestion Mr. Sieperstad made about the wide reading of the word circumstances in Pratt and Morgan, specifically at 961 letters E to F, the focus in Pratt and Morgan and in all the subsequent decisions of the Judicial Committee which I showed you yesterday, so Guerra, Henfield, Fisher and Thomas, was on the carrying out of the sentence after a period of long delay. So those were the circumstances. The only additional example of circumstances potentially capable of leading to commutation being the extreme example which Lord Millett gave in Thomas, of a man kept in solitary confinement, shackled, flogged or tortured. And it's for that reason that the respondent was driven yesterday to give an example of someone who's been detained on death row for 50 years and during that time was subjected to flogging and torture. That was Mr. Sieperstad's example. But that, with respect, is neither this case nor the typical Pratt and Morgan case. And that simply does not arise for consideration on this appeal. The respondent submitted that the court is called on to remedy the cruel and unusual treatment during the period of that treatment. That's what Mr. Sieperstad submitted yesterday. But with respect, that is not at all what the court is called on to do in a Pratt and Morgan case. And it's plainly wrong with respect. And we see that from all the cases, and that's exactly why I took you through them, to see what was decided. And in particular, we see it from Thomas at 1252 B to C, where Lord Millett explained that it's not the prolonged detention prior to execution which constitutes cruel and unusual treatment or punishment. It's the carrying out of the sentence after such detention.
Mr. Singh, I just want to understand one thing, and that is that if the commutation inevitably leads to a life sentence, well, what's the purpose of making representations to the Minister of the Mercy Committee and so on? Well, what's the purpose of doing that?
Well, my Lord, there are two things engaged here. There is the avenue of redress via the court, where the court considers what should be done and may commute and then has to give an appropriate remedy, and our submissions have been directed to supporting the contention that life is the appropriate remedy. And
so
then
there's no need for any representations at all to be made to the court, but there is a need for representations to the President.
Well, yes, executive clemency is quite a different matter because there's a completely open-ended power in the President to do anything he wants. But my Lord says, I'm sorry, my Lord.
I do apologise.
No,
yes, okay.
Well, no, I think it should be me who's apologising. I was just going to try and answer the first point about no representations. In a typical Pratt and Morgan case, that is the consequence of our submission, yes. But one can conceive of the case, the extreme example of Lord Millett or Mr. Sieperstad, or potentially the example which I accepted was arguable that my Lord put to me about treatment after the 5-year period and whether that might sound in damages, which I accept it could potentially in an appropriate case. But my Lord, the consequence you put to me is simply the result of what we say the answer is, namely that in the circumstances of a typical Pratt and Morgan case, the appropriate sentence is a life sentence, and I must accept that that does lead to the conclusion you put to me.
And just whilst I'm asking questions, at page 420, paragraph 19, you raise a preliminary point, which, to my understanding, was not raised in the courts below.
No, and it's not a point I've developed orally, and it's not a point I take on this appeal.
Right. I wanted to exclude it, in fact.
My lords can take it that my submissions orally were the position we take.
Yeah. Okay. Because there are concurrent methods of proceeding.
Yes,
and you're not saying that
no,
it's inappropriate to follow the constitutional claim as opposed to the presidential.
No,
yeah.
No. But I think what we were, perhaps elsewhere as well, seeking at least to draw to the board's attention was something that Lord Hughes, in fact, I think said in Lendor at some point. I can't now remember, which is that. And it was clearly the expectation in Pratt & Morgan that in the ordinary case, executive clemency may well sort out the problem which may otherwise require a constitutional claim. But no suggestion that it has to be pursued first or that you can't bring a constitutional
Or there is an abusive process.
No, none at all, my lord.
Thank you very much indeed. Thank
you. My lord, the respondent also drew attention to the summary of the argument in Pratt & Morgan at 948, letter B to letter C. It was a very short bit of the argument, on the basis of which the respondent effectively submitted that because the appellants were asking for life imprisonment, that's what they got. That was the thrust of the submission. But with respect, it's clear, based on the passage, ironically, that the respondent himself relies on in Pratt & Morgan at 966A, that the board in Pratt & Morgan considered what was an appropriate order in the cases of the two appellants. So it can't be said that life was the consequence or the outcome simply because that was what was asked for. You can't have it both ways, with respect. Now, my lord, can I just deal very briefly, or touch on at any rate very briefly, Section 69A of the Interpretation Act, accepting, as of course I do, as was pointed out, I think, by my Lord Lloyd Jones, that the wording of that section, which includes that where punishment of imprisonment for life is provided for a criminal offence by any written law, does not clearly apply in a circumstance where a remedy is being granted.
Lord Stevenson.
I do.
It was Lord Hamblin. It was Lord Hamblin.
Oh, well, my lord, I apologise to all of you.
I beg his pardon.
At any rate, I see the force of the point. What I do say, though, with respect, is that we nevertheless, in Lendor, have Lord Hughes at page 783, letter A, saying this: nor does the necessity to avoid cruel and unusual punishment mandate the attachment to every life sentence of a minimum tariff term of the kind which is required in England and Wales and permissible to courts in Trinidad and Tobago under Section 69A. Now, he's clearly there saying that it is available to the court under Section 69A in the context of commutation, because that's what Lendor was about, albeit in the executive clemency context. There is also, and it may be...
I don't quite follow that. Section 69A, as I understand it, is a view being expressed to the executive, which the executive can either take into account or can reject. And so it's not a tariff in the sense that we know tariffs.
Well, I wasn't necessarily suggesting that it was, but my Lord Hughes appeared to be equating the two in that passage. And I had a look at the rest of the judgment and the argument, and I can't see where that actually came from, my lord.
I'm not quite sure why the relevant power under Section 14.2, which seems very wide, couldn't extend
I think it could, my
Well,
Lord.
potentially to both forms of tariff, both an expression of a view and a
Or an
tariff
or-
in the
Fixing a
English
tariff.
sense, yes.
Well, my Lord, that's exactly what I was about to say. And it may also explain something else, my Lord, because your Lordships were sent but hadn't received them or had an opportunity to look at them, a number of judgments this morning by my learned friend, which I was provided with at court and had the advantage of having paper copies, which I've been able to look at. Those were Beccles, Pittman, and Abraham. Now, those were cases in which the criminal court did what Hunt and Khan has now explained they can't do, but nevertheless, in each of those cases, as a result of the effect of Pratt and Morgan, alternative sentences were imposed. Actually, in each case, it was a life sentence. So, in Beccles, it's on page 21 of 21, there are no numbered paragraphs. You will see when you look at it that the sentence of death is set aside and we substitute therefore a sentence of life imprisonment. We further order that the appellant be not released before the expiration of 25 years. So, my Lord, that may be an example of an order that could be made under Section 14. Then in Pittman...
Just stopping there.
Yes, my Lord.
Your proposition is they couldn't make that order. They would just have to impose a life sentence.
My Lord, what I've said is a life sentence. What my Lord Sales has put to me is that could be done. And
that could be done if you're resentencing. But your proposition
could be done under Section 14.
It could be done under Section 14. Yes. But your proposition is that under Section 14, all you do is impose a life sentence.
My Lord, I have submitted that.
Yeah.
But having looked at these cases and taking stock of what has been put to me by my Lord Sales, I can see the force of the point that you could, from that appropriate sentence, nevertheless graft on a minimum term order, a tariff term order. It's not our submission, but I can see that it could be done in exercise of the power. So it's not what I am saying the board, saying what ought to be done or what should be done. What I'm submitting is it should simply be a life sentence, and I'll come to the review mechanism, which we say is an important part of that in due course. But what I do accept, if the board is not with us on that, is that the power under Section 14 would entitle the court to go that further step. So it's not my case. It's something that I accept the court could do if it is open to the court to exercise that power over and above what we have submitted, which is a life sentence. My Lord, in Pittman, at paragraph 72, your Lordships will see that the sentence was commuted to one of life imprisonment, I quote, not to be released before the expiration of 40 years. And finally, in Abraham, at paragraph 19, we substitute a sentence of life imprisonment not to be released before a minimum of 15 years and 10 months. Now that, I speculate, but that could be because the court is taking account of time served, for example, because it's difficult to understand how that particular period is otherwise reached. But anyway, there it is.
Mr. Stevens, yes, before you go on, do you draw a distinction between release under what I'll call the prison rules review mechanism and what I'll call inelegantly a straight presidential pardon?
Well, a straight presidential pardon can be subject to conditions.
Yes, it can.
So it might depend on exactly what the president did, but the two could amount to the same thing.
Yes, I'm wondering about your submissions about the possibility, if the board is against you on at one point, the possibility of a court specifying a minimum term. May that be effectively binding on any release under the prison rules review mechanism, even if not binding on the president?
Well, my submission, I think, as a matter of principle in response to that, my Lord, would be that it would undoubtedly mean that the reviews under the prison rules could not result in release before the expiration of what I'm going to call the minimum term or minimum period.
Yes.
nothing would prevent the President separately, in exercise of the prerogative of mercy, acting.
Thank you.
My Lords, can I now go back to what is perhaps the most important part of this from my perspective, and deal with the submission made by the respondent that an appropriate order under Section 14 must have regard to fundamental rights. That's the way Mr. Sieper's had put it. As an abstract proposition, that is undoubtedly correct. But in our submission, in the context of an application for constitutional relief, where the underlying sentence remains a lawful, a constitutional sentence, and the complaint relates not to the sentence, but to the carrying out of it after long delay, having regard to fundamental rights, as it's put, must, we submit, take account of that lawfulness, that constitutionality of the underlying sentence. Moreover, in an application for constitutional relief under Section 14, the Court is asking itself, what is an appropriate order to remedy the alleged breach of the Constitution? So the Court's focus, as I submitted yesterday, is on the breach. Here, the breach is not, categorically not, the arbitrariness of the sentence of death, precisely because it is a constitutional sentence. And the effect of the Court of Appeal's reasoning, and we say the respondent's submissions, is to disregard the fact that constitutional relief is being sought in a situation where the underlying sentence remains lawful, and in that sense, an appropriate sentence for the offence. So it's tantamount in our submission to asking the Court to shut its eyes, in effect, to a clearly relevant consideration when determining what is an appropriate order to make, namely, that the clear effect of the Constitution is to preserve the mandatory death sentence. That's, of course, the effect of Section 6, and so I don't accept that Section 6 is irrelevant. It is appropriate redress by way of a substitute sentence in that specific context which the Court must determine, and not the sentence which might have been imposed if the sentence for murder were discretionary. And it's that would be, as I submitted yesterday, to give the Court a discretion contrary to the clear legislative intent behind Section 4. Furthermore, if the original sentence remains a lawful sentence and is the sentence for murder irrespective of the individual circumstances of the offence or the offender, it cannot be said that life imprisonment is not appropriate because it fails to take into account the individual circumstances of the offence and the offender. And in my submission, very respectful submission, that there is no question of the state benefiting in some way from the mandatory nature of the death sentence, as I think my Lord Sales suggested it might be said of what I was submitting. Rather, the outcome for which we contend is the consequence of the fact that this is an application for constitutional relief where the underlying sentence remains constitutional, and the appropriate remedy is determined by reference to the breach complained of, the carrying out of the sentence. And that's what Lord Hughes was saying. I won't repeat it in Lendor at paragraph 11, which we say applies in this case. And it's for all those reasons that the first issue that has to be addressed is what is the nature of the exercise engaging the Court. So, in summary, my Lords, the way we put it is this. The Court is not sentencing ab initio. nor is it granting relief against an unconstitutional sentence. It is granting relief against the additional cruelty of carrying out the lawful sentence after long delay. So you start from the position that the original sentence is lawful but cannot be carried out. The appropriateness of the substitute sentence then falls to be measured in that context, not by reference to the circumstances of the offence and the offender. And there's no question of the state taking advantage of the savings clause in section 6 in respect of the substitute sentence when there's no attack on the original sentence, only on carrying it out. And it is that to which the remedy is directed. So, although the fact of commutation means that an alternative sentence must be imposed, that does not mean that the court, when considering the claim for constitutional relief, is engaged in a sentencing exercise, and that was the error of the Court of Appeal. The relief will take the form of an alternative sentence, of course, but the court is still exercising its power to make an appropriate order to remedy a constitutional breach. And, my lords, I said I'd come back to the review provisions, and I do that in conclusion. The review mechanism will itself guard against the substituted sentence, substituted sentence, we say life, operating disproportionately, because the 4 yearly reviews will themselves take account of the particular offender's case, as Lord Hughes explained in Lendor. And it's very important to appreciate exactly what Lord Hughes was saying in Lendor, because there's been criticism directed at the way the sentence operates in practice and of the absence of legislation and of the executive nature of the control over it. But what Lord Hughes explained in those paragraphs to which I took you, which I invited you to read for yourselves yesterday, was that the provisions for review in Trinidad and Tobago, which can lead to release, exceed the minimum requirements contemplated by the Strasbourg cases. And cater for any complaint of absence of review or irreducibility. And moreover, that there is a judicial remedy by way of judicial review, the rules of natural justice pertaining to the process. My lords, within the overall time limit, those are my respectful submissions in reply, unless I can assist any of your lordships further.
Thank you very much, Mr. Stevens. We're grateful to all counsel, and also to those sitting actually or notionally beside. Oh no, indeed. Well, Mr. Sipersad did not have Mr. Millington immediately alongside him, but the screen is just there. So we're grateful to all counsel in the case and to those sitting behind them for the preparation of this appeal. And we will take time to consider our decision. Court is now adjourned. Thank you very much.